Nobody wants to go to jail. And if you go to jail, you want to get out as soon as possible. So one of the most asked about issues I receive in criminal law is about bonds, bond reductions, and bond hearings. Today, we're going to take you out of the crowded courtroom and explain bonds. A bond will be set in your case either when a judge issues an arrest warrant or at first appearance hearing if you were arrested without a warrant or were arrested with a warrant with no bond attached. Here in Duval County, the judge will not change the bond at first appearance if it was already set by a judge who issued the arrest warrant in the first place. Unless you are charged with a capital felony like murder or capital sexual battery or an offense punishable by life, and the judge decides that the proof is evident and presumption is great in that case, you are entitled to a bond. Now, in theory, the judge is supposed to consider many factors, including the nature and circumstances of the offense, the penalty, the weight of the evidence against you, your family ties to the community, how long you've lived in the community, your employment history, whether you can afford bond, your mental condition, your criminal record, whether you pose a danger to the community, and other factors. The judge is supposed to set the minimal conditions of pretrial release, including the lowest bond amount, in order to ensure your appearance at court and to protect the community. Now, in practice, many times things go a little bit differently. Judges may set hundreds and hundreds of bonds per week. Here in Duval County, there are usually over 100 people in first appearance court every single day. That means that the judges are not going to spend a whole lot of time considering all of those factors in every single case. And they're usually going to set a similar bond for everyone charged with that same crime that has a similar record. The more serious the crime, the higher the bond is typically going to be. A lawyer can sometimes and often convince the judge to set a lower bond than usual by focusing on the important positive factors in the statute based on your particular case. In addition to setting a bond amount, the judges can also make other conditions of pretrial release. They can make you wear an ankle monitor and confine you to home detention. They can make you enter a pretrial services program where you have to submit to drug testing and other conditions. They can prohibit you from traveling or driving or drinking alcohol. Unfortunately, we are seeing more and more draconian pretrial release conditions, especially on first-time DUI cases, that have really affected people's lives and their ability to make a living. The judge can also release you on your own recognizance, or RORU, which means that you will be released without having to pay anything and without having any specific conditions of pretrial release. Unfortunately, in our jurisdiction at least, RORs are getting rarer and rarer. Now, once the judge sets a bond, let's say it's $10,000, you could pay that $10,000 to the court, and then you would get the entire amount back as long as you complied with the pretrial conditions and showed up to court throughout the process. Most people don't have $10,000 on hand, so you can sign a contract with a bondsman. The terms are between you and that bondsman and may be negotiable. But typically, you would pay the bondsman 10% of the bond and put something of value up as collateral, like your house or some other property that you own. So if the bond is $10,000, you may hire a bondsman and pay them $1,000 plus pledged collateral. That bondsman is now on the hook for the entire $10,000 if you don't show up for court. And you don't get your $1,000 back no matter what, because that is the fee the bondsman gets for taking the risk in pledging the whole $10,000 bond amount to the court. Now, let's say that at first appearance, the judge sets a bond of $100,000 and you can't afford to make that bond. Or let's say that the first appearance judge didn't even deal with bond because it was already set by the judge who signed the arrest warrant. You can have your lawyer file a motion for a reduction of bond, where you will be able to call witnesses and present evidence to show the judge that you are not a flight risk and you do not pose a danger to the community. So you'll show up to the court and you won't hurt anybody or any property. When can you get your bond reduced? Well, that depends on the judge's calendar. The rules only require that the hearing be prompt, but doesn't define what prompt is. You must give the prosecution at least 3 hours notice before a bond reduction is heard. Your attorney should draft and file a motion to reduce bond and then have it calendared on the judge's docket. It is then up to the judge or judge's assistant to find time on the calendar to hear the motion. And sometimes your attorney can push that along a little quicker. If you violate the conditions of your bond by getting a new arrest or violating a condition that the judge set, the judge can revoke your bond for good cause and keep you in jail until your criminal case is over.